All right. Hello. It is Tuesday. Welcome to IP Chatter with Janelle. My name is Janelle Lacey. I'm an intellectual property attorney in Georgia. Today's also Cinco de Mayo and Taco Tuesday. So I hope you have something fun planned before this or after this, depending on when you watch it. Maybe a virtual happy hour / Taco Tuesday with your friends. All right, so today we are going to talk about copyrights. Today I'm talking to my authors, my artists, songwriters, playwrights, screenwriters, all of you out there who are making creative content. So what is copyright? Copyright is an original work of art. It's an authorship in some creative work. So if you write song lyrics, if you do beats for music, if you write music, if you're writing plays, if you are creating the art that is on the front of movies, magazines, or anything like that, that is covered under copyright law protection. Now, it is a vast area and a lot of things are covered under copyright. So just think of anything that is original, unique, artistic. That's usually what would fall under this category. So the good thing about copyright is that as soon as you create that work of art, you automatically have copyright protection in that art. So now the question is, well, why even bother registering it? Because you can register it with the Copyright Office. Now, there's some significant reasons for why you should register your work under the copyright protection. And it really depends on what you plan on doing with that work. So if you're just going to be writing in your diary, you're just writing some lyrics, or you're just making some pictures just for your own personal use and enjoyment, you're not really concerned if somebody copies it, if somebody else is using it or sees it, then copyright protection and registration might not be for you. However, if you're somebody who's going to be distributing your work out there, you're going to be performing that work, you want to sell it and that kind of thing, then you want to start thinking about copywriting your work. And here's the reason why. In order to file a copyright infringement, you must have that work registered under copyright registration. And so if you don't have your work registered, then you're unable to file an infringement suit. Now, you can retroactively file for copyright registration. So say somebody is infringing on your work, you find out, you can go to the Copyright Office, you can file for that copyright, and then you'd be able to ensue your infringement suit. However, if you haven't done that registration, you're unable to make that lawsuit. Another reason is there's particular damages that you're unable to get unless you have registered your copyright. So there's some statutory damages, there's attorney's fees, and in this case, you must have had that copyright registration before infringement ensues in order for you to get those certain damages there. So if somebody is if somebody is infringing on your work, this is a case where you cannot go back and retroactively file for that registration and be able to get those damages. So there may be some other damages that you might be able to get, but in that case, attorney's fees and certain statutory damages would not be available. So another reason why you want to register your copyright is because it gives you validity. What that means is it shows that you have a valid copyright registration, you are the owner of that copyright, and so what happens is instead of you having to prove that you are the author or the creator of that workmanship, the other person is now going to have to prove that you are not that creator or that you are not the owner of that work. And that's a much higher burden to cross than for you just showing that you have this registration that shows my validity. And now the other person is going to have to come and try to dispel that and disprove that. And that's a lot harder to do. So you want to ensure that you have those rights in place, and you want to have the strongest defense, or you want to have the strongest sense of ownership if somebody comes in and tries to sue you for infringement or something along those lines. Or if you need to sue somebody for infringement, you already have that protection in place saying that you are the rightful owner there. Another reason why you want to think about registration is because it puts the public on notice. So if you have a registration of, say, your next TV script, and you've sent it to the Copyright Office, and you can look up what has been registered under the Copyright Office, or if they see that you have that registration on your piece of work, then it deters somebody else from coming and infringing. Somebody will think twice before they start using your work, knowing that it is registered, and if they know anything about copyright law, knowing that if you file an infringement suit, that your chances of coming out on top of that suit are a lot higher than had you not registered it. So I like to say that most people, there's always an exception to the rule, but for the most part, most people will be deterred from going ahead and copying a work if they know that you have that solid registration with the Copyright Office. So now there are instances where you are allowed to use someone else's work and it doesn't count as copyright infringement. That's called fair use. So under the Copyright Act, there is a portion where the law allows you to use someone else's work for certain purposes. Now there's several different purposes that you're allowed to use it for. One would be for a parody. One would be for comment, it could be for criticism, for educational purposes, things of that nature. What you are not ever allowed to do is to take somebody else's work and claim it as your own. So I can't take Prince's Purple Rain and start performing it and writing lyrics and selling t-shirts with the lyrics on it and claiming that I wrote the song. I wouldn't do that. It's my favorite song of all time. But that's what I'm saying. So I could talk about the song, I could talk about the lyrics if I'm making commentary about it, or if I wanted to make a parody or something over the song, I could do that, and it could possibly fall under that Fair Use Act. But you can't take that work and use it as your own. That would be an infringement. So another thing that I see a lot on social media is people will be playing music in the background of whatever their video is, and they'll put a disclaimer saying that I don't own the rights to this music, or I'm not the owner of this music, or something to that effect. Well, that really doesn't matter because you're still infringing, okay? You could put whatever kind of sign you want up there. Unless you have permission from the owner of that copyright, you are infringing on their work, or unless it falls under one of those Fair Use Acts. So putting that little disclaimer up there is almost like admitting that, hey, I don't own these rights, nor do I have permission from the person who does own these rights, and I am in effect infringing on this copyright. So just something to think about. Another thing that you want to think about is for my artists out there, or even for my music artists, my painters, drawers, whatever kind of art that you're involved in, if you sign an agreement with somebody, make sure that you are maintaining your copyright in whatever your work is. So I volunteered with a legal arts department, and we had a lady who wanted to sell her paintings online, and she came to us and she wanted to make sure that she was going to maintain her copyright in her art while she was selling it to this internet gallery. And so if you sign any contracts, or if you are licensing your work or something to somebody else, you want to make sure that you are maintaining those rights and that you are not in effect giving up those rights within that contract. And that's just an aside that you want to be careful when you are selling your work, or if you are displaying your work in somebody else's gallery. So keep that in mind. Another interesting topic of copyright infringement is Twitter, social media. You do have copyright in some things that you post on social media. Now again, it needs to be an original work of art. So I can't put my top 5 all-time favorite movies and try to claim copyright in that list. That's not an original work of art. So an example for this would be Lizzo, one of my favorite songs that came out last year. Her opening line says, "I just took a DNA test. It confirms I'm 100% that," and you know where it goes from there. Well, she didn't write that. She actually got it from a tweet. And if you look at Twitter's user agreement, it says that the user who tweets, the user of Twitter who puts out a tweet has ownership. And of course, it has to be original work of art in that tweet. And so the person who tweeted that line, Lizzo saw it, she took it, she put it in her song, she made a lot of money from it. That person who originally tweeted found it and threatened to sue Lizzo. And well, guess what happened? Instead of going to court, Lizzo gave her songwriting credit. So be careful, again, my artists out there, if you see something and you like it, and it happens all the time, make sure that you're not copying it, because that could land you in a lawsuit. Now, that person probably didn't register their tweet, but look what happened. They didn't end up going to court, but now she's having to share royalties and songwriting credit because of that one little line. And it's just a couple of words, but that completely changes the outcome of her work and of how much money she's going to be making. So you always want to keep those things in line. Another example of fair use, this is one of my favorites from law school, is there was a company called Chewy Vuitton. So they were making fun of Louis Vuitton. They actually were making dog products. They were making sleeping bags, or not sleeping bags, but carrying cases for animals and dog treats and toys and that kind of thing. And they had the same sketching as Louis Vuitton. They used the CV in the same way that Louis Vuitton uses their LV. Well, Louis Vuitton said, wait a minute, you're infringing on our copyright here. It was trademark copyright and something else that they were also suing for. Well, the court actually said it's a parody. They're making fun of you, and that's okay. And so in that instance, this Chewy Vuitton store was allowed to continue using their mark, their CV, and using it in the case of a parody without it being infringement. Now, there is kind of a thin line between that. So again, be very careful if you're calling it a parody. Make sure it's a parody. Now, if this dog store was using the actual LV and it was Louis Vuitton dog treats, absolutely, that would be an infringement. That would be they wouldn't be able to do that at all. So just a little bit of information there for you about copyright. I like copyright because it's pretty straightforward. It's to the point, and it's really something that you want to hold on to because it is your work. And so make sure that somebody else isn't out there copying what you're doing. And if you are somebody who's going to be making a lot of different work and putting that work out there, make sure that you are protecting it. Guys, as always, if you have any questions, please let me know. My email is posted below. If there's any specific topic or question that you want me to talk about, let me know and we'll go ahead and chat next Tuesday. We've talked about overall intellectual property, trademarks, copyright. Next week will be my absolute favorite. We're talking about patents. Yes, I'm so excited. I can't wait. I love patents. So meet me here next week. Have any questions in the meantime, let me know. Thank you guys so much for your likes, your comments, and watching. Have a great one.